Hello everybody, welcome back to the channel, to the Butterfly Monkey Effect. Today will be a chapter on affidavits. Specifically, the chapter is going to be in Suits of Chancery by Gibson. And I want to give mad props to a young lady named Ella, or Ellen. I do not know her from Telegram, but I met her on TikTok. And by far, it was the first time in a very long time where I listened to someone and I felt clueless in terms of what she was saying in regards to equity. Her knowledge on equity from just a couple times I heard her talk had me guessing. So this was recommended by her for people to read. So I will read. I'm shocked that I never read this. There's other portions of this book that I read in this, but she also showed me that I was lacking in my understanding in equity, especially since I'm, semi-versed in contract law and trust law. So this right here is something that I was missing, and I paid too much attention to the other two. So I will probably be researching and reading some equity coming in the future, and probably making videos more in depth, in detail, with the procedures and process and so forth like that. No different like how this is affidavits. I know how to write affidavits, but that's of course, from reading American jurisprudence or case law, or even, my state statutes and so forth. All right, so this is chapter 39, affidavits, section 784 out of Suits and Chancery by Gibson. Office of an affidavit. An affidavit is a statement reduced to writing and sworn to before some person authorized to administer the oath. The ordinary offices of an affidavit are: 1, to aid in supporting or opposing an application for an order of the court, whether such application be based on a motion or on petition. To serve as a substitute for an officer's return of service of process, notices, and other papers. 3, to verify bills, answers, and pleas when verification is necessary. And 4, in general, to bring before the court facts which do not otherwise appear in the record of the cause. And that's literally, and they call it offices, but these are the criteria of, or the context of why you're writing an affidavit. Affidavits are ordinarily needed in support of motions in the following cases. 1, motions for publication when personal service is dispensed with. 2, motions for the appointment of guardians ad litem. 3, applications for process without bonds for costs or damages. 4, applications for an injunction. 5, for an attachment of property, or 6, for a receiver. 7, motions to set aside a pro confesso. I don't know what that is. 8, to extend the time for taking proof. 9, to re-examine or witness to the same facts. 10, for the continuance. 11, for an attachment for the contempt. 12, for the better prosecution surety. 13, for the new trial, for a new trial or rehearing. 14, for leave to file a bill of review for new facts. 15, for retaxation of cost. And 16, for all other cases wherein the grounds of the motion do not already sufficiently appear on record, of record. Pro confesso. Let's see if we can look this up real quick. Something general. If this would give me something. And apparently my internet don't want to work. So we'll ignore that for now. Affidavits are not part of a court record. even if filed, unless made so by a bill of exceptions. Right? Filing is one thing, being part of the record is another. Or by an order on the minutes by the nature of the bill of exceptions. All affidavits read in a cause should, however, be duly filed, and the court may decline to hear them until they are filed. So filing is one thing, on the record is another. Section 785, by whom affidavits should be made. As a general rule, an affidavit should be made by the person who has personal knowledge of the facts unless a good reason is shown for its being made by some other person. An affidavit may be made by an agent or by a solicitor when he has personal knowledge of the facts, but as a rule, not otherwise. The leading affidavit should be made by the party himself unless he is sick or absent, or the suit is being conducted by an agent or attorney. In fact, corroborating affidavits may be made by anyone having personal knowledge of the facts. Where however, the facts are peculiarly or personally within the knowledge of the solicitor, his affidavit should always accompany that of his client, especially when diligence, good faith, surprise, or want of notice is involved during the progress of a suit. Let's see what some of this annotation says here. In judicial proceedings, nothing is believed unless sworn to. The judges, solicitors, attorneys, clerks, sheriffs, and other officers of the court are all sworn, and what they do and say officially is under the sanction of their respective oaths. And his affidavit should show that he is acquainted with the facts. The general rule of evidence that the best evidence obtained must be produced is as applicable to affidavits as to other evidence. Affidavits should therefore be made by those best acquainted with the facts to be proved, or a sufficient reason given for those not being so made. And all writings referred to in affidavits should be exhibited, or a sufficient excuse given for not so doing. I'm not going to read those. When a married woman sues by next friend, her bill should be sworn by herself unless the facts upon which the bill rests are peculiarly within the knowledge of the next friend, and the bill or affidavit so shows. The next friend of an infant generally signs and swears to the bill unless the infant best knows the facts and is of suitable age. In this case, he may sign and swear to the bill. So they're stating without defining, right, the next friend as a term unto itself. I wonder what that would mean in an equity dictionary, right? By next friend. The bill of a corporation must be sealed with the seal by the corporation if it have one, and if it needs verification, must be sworn to by some officer or agent who knows the facts set out in the bill. And for most cases in most states, right, a seal has been abolished. Right, it's more of a traditional type thing, whereas not as a legally binding thing anymore. Even though probably some states still recognize it, but here in Illinois they don't. It's more decorative and stuff like that. It can have some meaning, right, but not to the extent how it used to. Signatures or autographs, right, are the thing. Petitions should be sworn to by the petitioners and not by agents or solicitors. Answers must be sworn to by the defendants filing them, if adults and of sound mind. If infants or of unsound mind, their guardians or guardians ad litem must swear to their answers. You know, it's funny they don't say parents because in reality, infants is just someone not of capacity, right? So guardians include parents because it's a legal term, not like a personal term, right? What is that? From the law of persons, right? Of domestic relations. Section 786, requisites and frame of an affidavit. The ordinary parts of an affidavit are 1, the proper title or style, 2, the venue, 3, the name of the deponent, 4, the substance or statement of facts, 5, the conclusion, 6, the nature, the signature, and 7, the oath of the jurat. These parts will be separately considered. Number 1, the title or style of the cause. An affidavit must be correctly entitled in the cause or matter in which it is made, and an affidavit made in one cause cannot be read for the purposes of obtaining an order in another cause. But in proceedings for contempt against a witness for another person not a party to the suit, all affidavits subsequent to the order for the attachment should be entitled to the name of the state, in the name of the state. On the relation of the party prosecuting the attachment against the person attached. In entitling an affidavit where the parties are numerous, it is sufficient to give the name of the first complainant and of the first defendant, adding and others or et al. Thus, John Doe et al. Versus Richard Rowe et al. Which is common if you guys read case law. The venue should appear on the face of the affidavit so that it may be known in what county and state the oath was taken. The venue may be placed next below the style of the cause, or it may be prefixed to the jurat. If the affidavit is sworn to in open court and the jurat so shows, that is sufficient evidence of the venue. The name of the affiant. The person making the affidavit should begin his statement by giving his name, the place of residence, and if he is a party or has any connection with the suit or is a solicitor, witness, or officer, he should so state. It is also often important to state his age and business. These facts often add force to his statements. If I had to guess the force, right, it would mean the type of person you are, right? So like if you were to state not just your name, but that you're a pastor, a community leader, right, in some context or another, that holds weight into who you are as a character. It also, though, right, when you're giving information like that, it also affirms some form of jurisdiction, right, for those who are afraid of that stuff. So you got to understand what it is that you're doing, that information that you're additionally giving, especially if you're giving your business, right? I see no issue with them. You guys have seen probably some of my paperwork affidavits on how I write my stuff. So it is. These facts often add force to his statements. I thought I read that. Number 4, the substance or statement of facts. An affidavit must be pertinent to the application based on it and must be free from proxlixity. I don't know what that is. Impertinence and scandal. Let's see if this has come up at all. Look at nothing even came up. Pro confesso. What is pro confesso and how does it work? Pro confesso hearing. A pro confesso hearing occurs when a defendant fails to respond to a complaint or appear in court, often in equity cases like divorce or foreclosure. So it's to contradict. For whatever reasons you couldn't show up. Might as well look up what this is too now. Prolix, noun from prolix. And it's not giving me our meaning here. The state or quality of being unnecessary or tediously wordy. Verbosity. An affidavit should give all the necessary circumstances of time. So they're telling you don't be wordy. And if you read the modern versions, they don't use this word, but they tell you don't be wordy. Super plusage or words like that they use today. An affidavit should give all the necessary circumstances of time, place, and manner, and other material incidents, and its matter should be sufficient when considered by itself or in connection with other affidavits to warrant the application based on it, or supported by it. The matter it contains and all the material circumstances attending it should be stated positively so that the court may be fully informed as to the truth of the matter. An affidavit should give facts and not hearsay, opinions, inferences, or conclusions of law, which many of you motherfuckers do. When the deponent swears to words spoken, it is a proper precaution to add or words to that effect. Affidavits ought also to be legibly written in ink and in one handwriting, without any interlineations or erasures except such as are noted before signing. And, that's when you want to make changes and it might be too late to rewrite it. You got to make your change and note it. You got to initialize it and so forth. The conclusion, after the substance or statement of facts have been set forth, an affidavit usually concludes thus. And further, this deponent saith not. I'm glad that I write like that. This conclusion, however, is not essential. It is intended to mean that the deponent has no further knowledge on the subject, and it would be highly culpable in the deponent to surpass any facts that would nullify or materially modify the statements made. So that's a great thing to add to your paperwork. I have never read the reasons why that's there. So this right here is new to me. It's not in anything else that I have read. That verbiage, that writing right there. I've seen it in documents like trust indentures, right? They're after the writings that people are doing and stuff like that. So, and contracts and so forth, which is one and the same. The signature. An affidavit must be duly signed at the foot thereof on the right-hand side. If the affiant can possibly sign his own name, he should do so. If not, he should make his mark, and his signature should be duly witnessed. The oath and jurat. The deponent must not only be duly sworn to the truth of the contents of his affidavit, but the officer must also certify that fact in a jurat writing at the foot of the affidavit upon the left-hand side. The jurat should be duly dated and signed officially. So here's something that I almost guarantee no one does, okay? Most notaries will not duly swear you. They don't actually say the words. They read the thing right to themselves, like especially if you write your own jurat, right? You write your own the form or whatever, the ending. That's for him to sign. That's one thing, but it's one thing when you write it, because then it's like you're duly sworn because you're stating it too, right? But man, it's like it needs to be stated. So like if they were ever hauled into court for whatever thing, and for some reason they say, oh my God, I never read it to him. There it goes, right out the window. It's little. I mean, it's petty, right? Because of the conversation, the look over of the paperwork and everything, there should be some form of understanding between you and your notary, right? But just imagine that scenario if you're in court, if a notary ever gets called in and he says, no, I never verbally said it to him, to make sure he understood what was going on. Form of an affidavit, and they give you an example. And this is the same thing I do. Actually, in the beginning, I write down the state and county right here at the top. This pertaining, of course, would be a court case thing. But an affidavit in general, where you're trying to submit it, that is not a versus, not a case yet. I would write the state or the county and the state. John Den, duly sworn, says that he is a resident of Loudon, Tennessee, is 38 years old, and is a farmer and school teacher, and that he knows of his own personal knowledge the following facts. And further, this deponent says not. Deponent saith not. And then here's the juror, subscribed and sworn before me. I have a nice one, right, for their signature, right? I got it from old documents and stuff from Illinois court cases and shit. But, you know, it's basically the same everywhere else. A couple more pages, I think. Weight and effect of an affidavit. Courts act only on what is sworn to, and when a fact or state of facts is duly verified by the affidavit of a competent person, the court accepts such affidavit for the particular occasion as absolutely true, unless it is highly improbable or unreasonable, or is self-contradictory, or vague and unsatisfactory, or is merely on information, or is contradicted by the record. Thus, where an affidavit, whether of a party or of another person, is required in support of a motion or petition, which it is its proper office, it is ordinarily received for the purpose as conclusive evidence of the facts it contains, and and the like effect should be given to them by the master when used in support of motions before him. And if you guys remember the stuff that Trump was going through, what were they talking about? The court. It tells you what court he was going to when he was talking about, and they were appealing or writing in regards to the master. Section 788, affidavits to bills, petitions, pleas, and answers. All bills and petitions that pray for extraordinary process, such as bills for injunctions, attachments, or seats. I don't even know what that word is. And receivers, all bills for divorce, for the appointment of administrators, for the sale of property of persons under disability, or to set up lost instruments, or to have an inquisition of lunacy, or for a mandamus, or for a writ of replevin, all bills in this name for the state against corporations, public trustees, and usurpers of office, and all bills of interpleading, bills for the administration of insolvent estates, for the for the perpetuation of testimony, to take testimony, de ben esse. I know what essay means, de ben. I don't know. And to review decrees on facts, and all bills setting out facts, requiring the appointment of a guardian ad litem, or process by publication, must be sworn to, and all answers must be sworn to, unless the bill waives an answer under oath, or unless it be the answer of a corporation. Maybe that's why right there, let's see what the annotation says there, number 23. They give you a section, another section here. So section 379, note number 20, and I'm going to say page 789, which is this one. As to sworn answers of corporations. All pleas must be sworn to unless they are based on matters of record in the court, and all petitions presented to the court during the progress of a suit on which the action of the court is sought must be verified. But here, right, in terms of most things that people are facing with government, right, is look at this. It's like, this is the purpose of why you have to get it sworn, right? You're writing it in purposes for public against public trustees, usurpers of of the office and bills of interpleading. These are all things that many of these people in these communities are actually facing. The force of a bill, petition, or answer depends greatly on the character of the affidavit attached to it. What do you think they mean by character? Do you think they just mean by how it's written, or the substance of the person also? To the extent, right, that he's an honorable person, probably telling the truth, right? For no bill, petition, or answer can be any stronger than its verification. And if the verification is on mere information and belief, the pleading is but little more than hearsay. So if the verification is direct and positive, but by a third person who is not shown to be acquainted with the facts, it has but little force. An injunction bill sworn to on information and belief is utterly inadequate to withstand a motion to dissolve the injunction when the answer is sworn to positively and directly on the personal knowledge of the defendant. On the other hand, vain is the effort to dissolve an injunction when the answer is sworn to on information and belief, and the bill is on the direct personal knowledge of the complainant. The difference between the two is the difference between hearsay and evidence. The answer on information and brief simply makes an issue even when an answer on oath is called for. Man, this is actually perfect for me, right? Because I believe that I will get denied for a passport, right? And because they have no process for a hearing on a denial for the lack of a social security number, I have to file suit, and I have to file for an injunction to stop them. This right here is going to help me greatly. Like, for real. $789 forms of affidavits to bills, petitions, pleas, and answers. The form and substance of affidavits to bills, petitions, and answers are substantially as follows. And they give you a couple of examples right here. It's the same stuff, but here you how they had it. Look at the state and the county. This is how I would write it, right? And mine would have been petition. You know what? And an answer. Not a bill. The ones that I've written. Or for the purposes, Another form and affidavit for the same. Same thing, county and state. And the same information. Except for if you're, the complainant or defendant, right? Complainant, petitioner, or defendant. Bills and answers are often sworn to is in such a defective or indefinite manner that they cannot be regarded as sworn to at all. Like one of those defects is if you don't go and verify your notary that she's still in honor with the state. The author has had numerous bills presented to him as chancellor for fiats with nothing to them to show verification except the jurat. The distinction between an affidavit and a jurat is sometimes overlooked. Shit, that's something probably we need to fucking understand the distinction between. If the complainant makes his mark, the better practice is to begin the affidavit thus, and they give you the example. When a bill, petition, or answer is sworn to by an agent, solicitor, or attorney, the affidavit should show that fact, and should also show the affiant's knowledge. This form will do when a bill or answer is filed by a corporation and is sworn by its president or other chief officer. In such a case, the following form may be used. I want to read the faithful makes oath that he is the President, Secretary or Treasurer of the Coal Mountain Company, the complainant, corporation, and that the foregoing bill of said company is true of his own knowledge, except as to the matters therein stated to be on information and belief, and that as to those matters he believes it to be true. And he hereto affixes the seal of said company in further attestation of the truth of its bill or answer. Affidavit to a plea in abatement or plea in bar. Before whom affidavits must be made. Affidavits to bills, petitions, answers, pleas and answers, and also to any statement or writing used for judicial purposes, and needing verification may be made before any judge, justice of the peace, clerk of court, a notary public in this state, and in another state before any judge or justice of the peace, accompanied by a certificate of his official capacity by the clerk of his court, or before any state commissioner or notary public under their seals of office. And they're stating it in another state, but they don't state to use it in this state. The court of clerk and master may appoint a special commissioner to administer oaths either in this or any other state. And that was the end of that right there. But that was a good little read. I'll probably do a little bit more on this right after I read more. Of course, I'm going to read some of these court cases for specific stuff. But all in all, this was informative. So thank you guys for watching. Hopefully that didn't come up on the thing. But have a good one, and let me know what you guys think. And again, good praise to Ellie for recommending this portion right here, because it's going to help me a lot with the following court case that I'm going to be submitting into the Northern District of Illinois. I already started it, so I no doubt I'm going to be amending most of this stuff. All right, guys. Have a good one, and until next time.